Welcome to Series 7 of the Lawyers Coach podcast. My name is Claire Rayson, and each episode of this podcast will feature myself and Oliver Hansard, both of us coaches and former lawyers trying to find out what makes lawyers tick. In this series, we will be hearing from various guests and experts to talk about the billable hour. And then, at the end of each episode, we will both be reflecting on what they said. The Lawyers Coach podcast is brought to you by Client Talk and Hansard Coaching. In this episode, Ollie spoke to Daniel Martin. Daniel is a partner and head of the Business Crime and Regulation team at JMW Solicitors. Ollie spoke to Daniel about the billable hour. They thought about the different options available to clients and in particular the impact of transparency. And at the end, thought about how hard it is to move away from what is something that is quite ingrained in the way lawyers work. But first, Ollie asked Daniel what got him into law in the first place.
I got asked this question recently about why I originally became a lawyer, and I couldn't actually recall. I think it was just because I thought I could get paid to argue with people.
Brilliant.
And as a teenager, that seemed pretty perfect. But no, I had always had an interest in it, in becoming a lawyer. Although I can't recall why. I did my A-level law sort of in the evenings at college because I couldn't do it because my school didn't do law. So I must have, had my eye on that as a career from quite early on.
So having done A-level law, you went on to university. So was that kind of doubling up when you were doing your degree then?
A-level law is just a taster really, but it definitely gave me a grounding in criminal law, which was the subject that I really loved right from the off. I really enjoyed that all the way through university. And then I qualified at a firm in Thames Valley, which was sort of a traditional legal aid criminal team. And I actually ended up sort of rising to head of that criminal department, and also became the compliance officer for that firm. And that's when I was approached by JMW about taking up a role in their London office, which was just over 2 years ago.
And what kinds of crime are you involved in? White collar or the full range?
So my team is very sort of broad church. We do everything from sort of general crime right through to corporate crime, regulatory investigations, corporate investigations, private prosecutions, which is a real growth area for us, as well as regulatory and compliance advice and support for businesses.
And so what are your sources of work? Do you do the traditional, down to the police station type work, or does it come in a different form?
We certainly do represent clients who are being interviewed at the police station. It's not the same sort of model that we used to have where we would be, going out in the middle of the night and attending the police station because of a duty contract call. We're only privately instructed. The interviews that we deal with are by invitation, normally speaking, and it's generally in scenarios which are involving allegations of fraud, business crime, regulatory, health and safety, that sort of thing. The investigative process is normally much more drawn out. There's many stages to it. There might be multiple interviews over the course of several years, all of which, you prepare in great detail for. So it's quite a different approach to that sort of traditional criminal team who might be sort of responding to a call from the police station at 2 a.m. and having to go out in the middle of the night.
So you must be in with clients in moments of intense pressure and stress. Is that commonplace in what do you experience in terms of delivering your services?
Absolutely. I think ours is one area. Divorce, family and divorce might be another, potentially employment as well, where you meet people at times of really, really difficult, periods in their life, when they're under intense pressure. They might have other considerations like family members who don't know what is going on. And so you're potentially the only person that they're really talking to about these things. And so, yeah, it can be a very, very intense situation.
I can imagine. So how do you build that relationship? There's obviously a very personal one, but needs to be strong in order to get the desired result.
I think it comes down to experience. Certainly when you've been doing kind of work for as long as I have, clients understand that you know what you're talking about, and that you are giving, sound tactical advice, perhaps steering them in a different direction than they instinctively want to go in. Over time, that, through that process, you build trust. So there has to be, a really high degree of trust between you and the client. And I think that you earn that through being able to demonstrate essentially that your experience and your knowledge in this area will tell to their benefit during the course of the investigation.
And then at some point you need to bill and collect the fees from the client. So how do you think about, one of the things we're interested in this series of the podcast is approaches to billing. And here there's the potential, I would have thought, of at an hourly rate, heavy cost there. How do you think about that in those very stressful situations to charge in a fair way?
Yeah, it's difficult. Again, this is something that comes from experience. It's quite often when I was growing up in the sector, I knew very, very good criminal lawyers who were technically good at their job, but they weren't particularly commercial in the way that they carried on their practice, and found it difficult to have those conversations with clients about costs. And, it is a tricky one, because sometimes you're going to have to flip from, discussing something which is really upsetting or really challenging to having a conversation about, costs and how you manage the situation financially as well. And so that can sometimes be, sensitive. Ultimately, it's really important to have clear advice, clear expectations around the costs involved. And I find actually that clients just really appreciate having more detail, more explanation around the way that we charge and what to expect. And also they value the service that they've received for that.
And so what does that look like? Is that regular updates, or is it saying, well, we're going to charge in a particular way for a particular part of the process? What different tools have you used to be transparent?
Well, we always try and I always look at things, and the way that I train my team to look at things is to look at the phases of an engagement and really sort of itemize out all of the different things that we should be thinking about and should be doing. And try as best as you can to give a sort of really clear itemized cost estimate based around an hourly rate in terms of what that's going to look like for the phase in front of you. The way that litigation works, it's very difficult actually to say, right, by the end of this case, you're going to spend X or Y, because there are so many variables during the course of a case that it makes it very difficult to accurately predict the end result is going to be. Let alone how much, it's going to cost to get to that point. So, but what you can do if you spend the time thinking about it is fairly accurately forecast what's going to be involved in the next phase of proceedings. So everything that you can see and anticipate at that stage. So we try and do that. We try and do that early on so that clients have that information up front. But we also, try and have conversations early on about what options are potentially available to the client, what different fee options we can offer the client that might suit their personality, suit their priorities better.
And some examples of the different options that might exist?
We are certainly trying to build on and develop sort of smarter options that complement different clients' needs, rather than having a one-size-fits-all hourly rate approach. So the thing, ultimately the thing we sell is expertise. It's measured in time. So fundamentally, the hourly rate sort of underpins everything else that we do. But the options that we sort of rely on quite heavily are fixed fees. There's variants of the fixed fee, but that option gives clients real sort of price certainty, certainly over the next phase of proceedings. And we've
so you might break it down, in block by block, the fixed fee.
Yeah, absolutely. So as I was saying, it's sort of looking at what we can accurately predict, which is over the horizon at the moment, and itemize and estimate that fairly accurately, and they're not offering a fixed fee option through to the end of that phase of work. It's been heavily adopted in my team. Clients really like the structure and certainty, and it allows us to sort of calibrate our resources to what the client can afford as well. I also personally do a lot of work in the area of financial services, investigations, advising finance professionals and traders, where we use a concept called hours bundles or hours bundling.
Okay.
And that seems to be quite popular, and it works well where you're collaborating very closely with another team. So in those types of cases, finance professionals, it's generally in a scenario where there's possibly an employment dispute or investigation, which has regulatory or even potentially criminal implications. So I'll be working hand in glove with one of my colleagues from the employment team. So what you can do there is you can agree a blended hourly rate between the two of you, which will apply for both of you, and offer but sort of hours bundles. And the client then has the flexibility and will benefit from a discount if they want to sort of block book additional hours. And so there's a cost saving to the client, and it's then up to them how they use that time between the two teams.
And that works
Really well. And it's simple, which clients like. The trick is to just be over the detail, I suppose, and be able to give the client a clear update as to, how that time is being used. And when you're approaching then, the end of the hours bundle, for example, and they can consider whether, too much time is being spent on one aspect and not enough on another. But it seems to work really well. It's been very popular since we implemented that. And we found, lots of people electing for that option.
Fantastic. And is there technology that you could introduce that might reduce the billing or make it more cost effective on both sides?
I'm a fan of technology. Anything that cuts down the time that lawyers spend on certain tasks can only be a good thing. Ultimately, that's going to reduce costs for clients. So, I'm a big fan of legal tech and where that can be used appropriately. A lot of what we do, though, is very strategic, not particularly heavily process driven or document heavy, certainly in terms of producing or reviewing documents in the early stages. So that sort of thing, it requires a human touch, and there isn't a huge amount of latency there to cut down through the use of technology, if you see what I mean.
Okay, so you don't do a lot of discovery type work or document management type work. It's
that
more
can come.
review.
That comes further. Can come later in big investigations where you start using things specific document review software. But certainly in the sort of early part of investigations that aren't sort of heavily complex fraud or anything like that, there isn't a huge amount of scope for using technologies to cut down time, other than the sort of e-discovery software, which can sometimes play a part. But no, it's quite heavy in terms of the human element.
As there's a growth in regulation more generally, particularly on businesses, does that mean this is a growth area for you and JMW in terms of a focus area for the business?
Yeah, absolutely. I mean, the government are looking at new areas to regulate always, and there's new corporate offences on the horizon. There's always something happening, in this space, and rightly as well. I mean, that post Brexit, there was discussion about whether we're going to deregulate, but really, I don't see that as being hugely likely. I think people recognise that, particularly, in most industries and finance, for example, regulation is incredibly important and really benefits society as a whole. So I think that regulatory work, will continue to be a growth area. We've sort of quite successfully diversified our services to really offer out our experience and expertise in investigations, fast-paced, stressful litigation to other areas that straddle criminal and regulatory law as well. So we try and work closely with other teams, personal and commercial teams in other disciplines, and provide sort of wraparound service for our clients. So that's something that, I've been really keen to build in my team, is the ability for our criminal and regulatory lawyers to think outside the box and, be more sort of, agile and dynamic in the way that they deliver advice to clients. And it really works in a sort of multi-service firm such as ours. Anything but traditional crime team in that sense.
Because there are so many facets to the type of work you do. You need support from other parts of the business.
We offer support to other parts of the business as well. So, quite often a fair chunk of our work comes from other teams coming to us with, specific queries or wanting us to collaborate on something or provide advice or support on an element which, it strays into the regulatory sphere.
Do you get many repeat clients?
So in a traditional sort of legal aid criminal practice, you will have, there's a concept called own client. You will have repeat clients and, people unfortunately who sort of find themselves stuck in the criminal justice system. That's not very common in our line of work because we're private only, and because of the nature of the work that we do, it tends to be when we're dealing in general criminal offences, it tends to be people who are being charged for the first time, and possibly the only time in their life. And so we don't tend to see necessarily repeat general criminal instructions from someone. But what we do see is that person, and actually in the firm, we've done some analysis around, clients who instruct one team and go on to instruct others. And in business crime regulation, our clients tend to be very high on the list of, if not at the top of the list of clients who go on and instruct other teams within the firm to do other things, other parts of their life, whether it's conveyancing, whether it's, divorce, whether it's business related, whether it's employment. So, and that stems, I think, from the trust that you build up with your lawyers.
So I'd never thought of that as your line of work being an entry point into the broader firm.
It seems to be that way. And I was quite surprised by that analysis when I first went through it. But actually, it made sense to me when I thought about it afterwards, because when you've had to go through that process with a firm and or with a solicitor, and you've built up that level of trust, it makes sense, doesn't it?
Absolutely.
To then feel comfortable and have that person on your side within the business as well. So I quite often act as a sort of relationship manager for people who have gone on to, do other things within the firm, and just be there as a sort of continued support as and when.
So that's great for the business, but it makes your job in finding the clients for you, that makes it quite tough, because as you say, they generally, it's a one-off with them. So there's a one-off relationship that you have that gets resolved in some form and you move on. So, your business development remains challenged, one would have thought.
It's true. So, you have the odd, repeat client who might have separate aspects to their case, or it might be a regulatory matter where there are, different businesses involved or something like that. But yeah, it does tend to be a sort of a single cycle. But what that does mean is, if you have done a really good job and, leave that person in a better position than you found them, well, hopefully they will go on and, recommend you to others. And we get a lot of sort of word of mouth recommendation. We get a lot of external referrals who come through other businesses that we've dealt with. So, for example, forensic accountants or tax advisors or whoever else that we've worked with on a case, and they, when it's come up in the future and someone's needed representation, they will say, well, we know a really good team who we can comfortably sort of recommend you to. So we see a lot of referrals coming that way, and also from within the internal market within JMW. So in London, there's a sort of booming internal market, because we've got, I think the last count, something like 16 practice areas, and people have sort of regulatory criminal issues coming up quite a lot, particularly in business, but often in their personal lives, or someone that they know, someone within their family circle or friends who they want to take care of and place with someone that they trust. So those internal referrals make up a large degree of our work as well.
This has been fascinating. Thank you very much. My last question is really, look, you've got so much going on in the London office. You've got changing regulation all the time. Have you ever been able to really stop and think, at some point what success might feel like for you?
I feel like I've already achieved more than I necessarily thought I would do when I started out. So everything from here on in is a bonus, really. I've been lucky in my career to catch breaks at the right times, and I just think that success for me really is just continuing to grow my team, trying to evolve and improve as a lawyer myself and as a professional, ultimately just to continue enjoying what I'm doing.
Brilliant. Thank you. You've been a fantastic guest. Daniel, thanks ever so much for coming on to the podcast. Your time's really appreciated.
No problem. Thank you very much for having me.
So that was Ollie talking to Daniel Martin. Oliver, what a great conversation. I particularly enjoyed Daniel's reflections on transparency.
Yes, I got a real sense of him trying to give clients as many options and trying to be as transparent as he possibly could when he's dealing with billing. He deals with clients in really tough corners in terms of the criminal litigation that they're involved in, and trying to break down the challenges and the billing associated with the different stages. I got that real sense of trying to be sensible in the way of dealing with the fees.
And where did you sense that pressure's coming from? Do you think that's coming from the clients themselves, internally, somewhere else?
I think really it's the reality of the type of practice he has, where he's got clients in very stressful situations, often the first time they would ever have been in any sort of criminal situation, really trying to be on their side, be with them step by step through the process, but also be kind in terms of how to deal with the fees associated with the issues that they face.
And what did you make of his idea or thoughts around bundling hours?
I thought that was really clever, because to give a blended hour rate and say, okay, look, to deal with this range of challenges that you have, here's a fixed rate, and as we go through the process, we draw down out of that bundle. I think that gives a client a lot more control and a lot better visibility in terms of the fees, again, when they're under often extreme pressure.
And do you think there's a temptation there to try and make sure that the person that's delivering is therefore, on the lower end of the scale? There are advantages and disadvantages to that, I guess.
I think it's about being fair both ways. The client needs that expert to help them through the process. I got a sense of a lot of what he does and what his team does is offering that support at those critical moments. So you need to be fair in terms of the expertise that is being delivered, but also fair in terms of the fees charged. So it's a real balance, I think, through the whole process. And maybe that goes for all legal transactions, I suppose.
And is that something that you would have welcomed when you were in-house?
Absolutely. For me, the key thing is breaking it down into stages and not getting that massive bill at the end. And I think that's something that Daniel's approach and that blended hours bundling approach addresses quite neatly.
So, Ollie, thanks so much for talking to Daniel. It was a really great conversation.
Thanks, Claire.
So I do hope you join us for the next episode, where I am going to be speaking to Adam Morley, who is the founding partner at Brandsmiths, a firm really making waves in the world of IP.
Lawyers Coach is brought to you by Client Talk and Hansard Coaching. If you're a lawyer and would like to take part in Lawyers Coach, please visit our website lawyercoach.co.uk for further details. And you can also join the conversation on our LinkedIn group Lawyers Coach. If there are any topics you'd like to hear us discuss, then just get in touch.